Good afternoon. Just for those who are joining us on time, we're just going to give another moment or two to let participants to join, and we'll start the webinar in about a minute or two time. Okay, so it's 2 minutes past 1, I think, in Canada, 2 minutes past 5 in Ireland. So I might start at that point. I just like to welcome you all, first of all, to this book launch for what I think is a conceptual and comparative tour de force. Dr. Paul Daly's new book, Understanding Administrative Law in the Common Law World. I'm delighted and very privileged to be invited to moderate this event. My name is Owen Carlin from the Centre of Constitutional Studies in UCD in Dublin. And I'm delighted to also and privileged to introduce such a distinguished panel to comment on the book. The format for the webinar this evening will be the panelists will each speak for around 15 minutes on their thoughts on the book. Paul will then respond as he sees fit to those comments. And if there's time, there'll be an opportunity for questions at the end. If you do have any questions, put them into the chat box. And as I say, if we do have time, we'll get to them at the end. Our first commentator this evening is Mr. Justice Gerard Hogan. I'm delighted to introduce Mr. Justice Hogan. He's been extremely influential, not only, I think, in Paul's work on this, but I think in general in Irish constitutional administrative law, and from his early days as a lecturer at Trinity College Dublin, where he was fortunate to lecture me at one point. He was also an extremely successful practicing barrister. He's gone on to be a distinguished High Court judge, distinguished Court of Appeal judge, Advocate General in the Court of Justice of the European Union, and recently appointed as a member of the Supreme Court in Ireland. I'm delighted to welcome Mr. Justice Gerard Hogan.
Thank you so much, Owen. It's a great privilege to speak at the launch, the virtual launch of this book, by a really distinguished and an exceptional scholar. And these are words that I wouldn't use lightly. And I really love the book. There's a freshness to the analysis and to a crispness to the writing style. And what I also like is that it introduces the reader to a variety of different common law jurisdictions without loading the reader with a wealth of authority, because for every point, I suppose, which Paul makes in the book, one could often cite dozens and dozens of cases, each saying slightly different things, perhaps from a variety of different courts and different jurisdictions. So I like the way in which this book is really a tour de force in terms that it surveys a range of common law jurisdictions, and there is a crispness and freshness in the analysis and in the writing style, which is extremely attractive. I'm going to speak on a number of disparate themes raised by reflections on the book. And the first point I would make is the importance of textualism, in the sense that if judges are faced with a particular problem, how do we know what law to apply? And for the most part, I think one endeavors to look for an objective source, the voice of, to use Holmes' phrase, the voice of the legal sovereign. And in a sense, I can only, as a judge, hear that voice through some established legal source, quite often nowadays in the form of a statute or statutory instrument, a written item of legislation emanating from Parliament, or in the context of the European Union, a regulation or a directive, and seek to interpret that by reference to objective standards. And that's why I think that while a purposive approach obviously has a relevance and a utility, the starting point, as even the Court of Justice would be the first to say, has to be the text itself. And I think we shouldn't lose sight of that because it is the, if like, the authentic voice of the legal sovereign, speaking not only to judges and lawyers, but also to the public at large. And it is the actual written word that has to be the starting point in our deliberations. And therefore, without wishing to be a pedant or overtly literalistic, I think that textualism as a starting point, not as an ideology, but as a starting point, is extremely important, because without a faithful adherence to the text, it's the text itself that gives a form of democratic legitimacy to what the judiciary are doing. The judiciary are seeking to effect to the legal command of the sovereign. And we can, in a sense, only know that by looking at the words as written down somewhere. Now, that's not, of course, to say that textualism is the be-all and end-all of statutory interpretation. Of course not. There are established, if like, sub-rules of statutory interpretation, including, for example, the presumption that Parliament or Legislative Assembly doesn't intend to change the law indirectly if there's going to be significant change affecting personal liberty or property or some other important right. It should do so clearly and expressly. There may also be cases where the precise problem presented is not adequately dealt with in the legislation, or where a literal interpretation would serve no particular purpose and would obviously be absurd. But to anticipate a point I'm going to come to next, there is a moral value to administrative law, and part of that moral value is enforcing the rule of law itself and giving effect to democratic legitimacy, imperfect as all that may be. And the way I believe a court should and must do that is start with the text. And by all means, you can deviate from the actual words, but if you're doing so, there has to be a good reason for doing so. So I think that part of that moral value of administrative law is supporting the rule of law and supporting the rule of law and the democratic legitimacy. So far as any raised challenge is concerned, it's not the court's own, obviously the court's own personal subjective views as to what would be good or what would be bad, but it must seek to objectively give effect to what the law ordains insofar as it can, with all its imperfections, but using the established rules of statutory interpretation. At all events, the text has to be the starting point, not because of some grammatical fetish on the part of the judiciary or some ideology on the part of the judiciary, but when all is said and done, it is the way in which a court best gives effect to democratic legitimacy. The second thing that I was prompted in the consideration of the book is I think the rules of law have been largely successful. One can quibble here and there, and one can argue that courts have gone too far in such a particular case and not far enough in another. And it may vary between jurisdiction, and may vary between the hierarchy of the courts, and may differ between individual judges and, of course, at different times. But I think on the whole, the changes that have swept through administrative law in the common law world since the 1960s have, on the whole, been very successful and have been an important part of modernizing the administrative law, ensuring the rule of law is upheld, and enabling the courts to deal with the vast in highly complex legal issues that the new administrative state and the expansion of the state and the expansion of legislative rules and regulations of a kind that were never understood or really happened before, ranging in areas from immigration to environmental law, data protection, a whole range of issues, that the changes in administrative law that, as I say, were ushered through in the 1960s, principally in England, but also in other jurisdictions as well, that those changes have been all to the good and have been successful. There is, however, I think, one exception. And I think there's one problem to which no court, I think, has really fully come to terms with. And that is the doctrine of reasonableness, irrationality, proportionality, or whatever version of this that you want to put forward. Because I think we can all agree that our respective parliaments never intended sometimes that the power to be used. There are instances where we can say Parliament never intended the law to be used in this way, or that it's manifestly arbitrary or discriminatory or irrational. And we can think of textbook examples of where, measured by reference to the statutory objectives in question, one can say X decision or Y decision should be condemned as being irrational. But those are sort of the textbook examples. In real life, it's much more difficult. And it's in real life in particular, it's much more difficult to devise a test of what one could call compendiously rationality review or reasonableness review that ticks all the boxes of deference to the decision maker, ensures that the judge doesn't step into the shoes of the decision maker, but at the same time ensures that there are real constraints on the exercise of power by the decision maker. I confess I haven't found it easy. And true it is that doctrines such as proportionality help to bring a new methodology and a certain objectivity to rationality and reasonableness review. But I don't think there's any easy formula. And that's one of the, I think it's one area of administrative law that it sounds great in theory, but presents a lot of problems in practice. Now, very quickly in the 5 minutes available to me, I mentioned the moral quality of administrative law. And I think one can see this in areas such as legitimate expectations, but also it's a key feature of, if you like, old-fashioned natural justice, or fair procedures, that it's part of the dignity of the individual that they be heard, and they be heard in a meaningful way. And one of the, I'm very grateful to Paul for having put some of the Irish cases on the map, because if we can say so, partly our own fault, I suppose, in some ways, but we're not as well known as a jurisdiction as some of the other common law jurisdictions, obviously Australia, New Zealand, and Canada, in addition to England and Wales itself. We sometimes tend to be overlooked, but there are many great Irish decisions from the past that any comparative jurist or scholar would do well to look at. And one of them mentioned by Paul is a case called Kiley and the Minister for Social Welfare. Very briefly, a case where a lady claimed that her husband had died as a result of an industrial accident. At the tribunal, it was said, no, he was heavy. He had cardiac problems and he smoked heavily, and that was the reason for his demise. But she and her GP were forced to go in this box, give evidence, whereas the tribunal simply accepted the minister's ipse dixit by way of a letter. and accepted the letter, whereas she was forced to give evidence and be cross-examined. And the Supreme Court held that, our Irish Supreme Court held that this was a breach of fair procedures. But Judge Henchy's judgment from 1977, in the 1977 Irish reports, speaks really to the moral quality of fair procedures, that it was wrong, in a sense, that a tribunal should stoop to a procedure which so manifestly disadvantaged one litigant as compared with another, and in a sense prefigured what the Court of Human Rights and the Court of Justice would call égalité des armes in terms of fair procedures. So I think there are many cases, if the rationale is one of the moral quality of administrative law, fundamental fairness, dignity, and respect for individuals is all part of it. And then finally, I'm going to say something about the scope of public law. There are some very interesting Irish cases on the scope of public law. One, another judgment of our great judge, Mr. Justice Henchy, a case called McCord and the Electricity Supply Board from 1980, where in a case concerning the interpretation of standard clauses in electricity contracts supplied by a monopoly supplier, state supplier, Judge Henchy wondered really whether this should be really dealt with by means of public law thinking, rather than just to treat it as a private law standard form contract between a consumer and a monopoly supplier. And that's a very interesting and almost radical idea, and certainly for its time in 1980. So those cases on the scope of public law are extremely interesting. But my final thought is this, does it really matter? Because conventionally, if you'd asked this question 20 or 30 years ago, you'd have said the difference between private law and public law was that within the sphere of private law, there's a field of personal autonomy where the individual, in general terms, with some statutory exceptions, is free to act perversely. I mean, I'm free not to contract with you because I don't like you, or out of ill will or something of that kind. I mean, the classic example of the bachelor testator with no family obligations who perversely decides to leave to favor X in his will rather than Y. Now, that's thought to be one of the differential features between private law and public law, in that public law powers are supposed to be exercised not for personal gain, but rather in the public interest, and that distinguishes them from private law. But I wonder whether, with the development of principles such as the doctrine of good faith in the sphere of contract law, whether that classic distinction between public law and private law is quite as true now as it was. And therefore, if that is so, and that and whether, and if it is so, it's because of developments in private law. Does it now really make as much of a difference as it might have had 20 or 30 years ago, whether a particular body or entity, such as a sporting organization or whatever, or a university, is governed by public law or private law? But ladies and gentlemen, I mean, those are just some weak thoughts prompted by a consideration of really what is an excellent piece of comparative administrative law analysis by an exceptionally distinguished scholar. And it's a great privilege and honor to be able to speak briefly on this webinar tonight. Thank you very much.
And thank you, Justice Hogan, for those comments. And then from one expert in comparative public law to another, our next speaker this evening is Professor Alison Young, who's Sir David Williams Professor of Public Law at the University of Cambridge and a widely published author of the area. Her books include Parliamentary Sovereignty and Human Rights Act, Democratic Dialogue and the Constitution, and many, many articles touching on the issues that Paul addresses in his book. Professor Young.
Thank you very much, Owen, and thank you also to Paul for giving me this wonderful opportunity to discuss his book. I will also begin by heaping praise on what is a wonderful book that I really enjoyed reading. It's always wonderful to see public law discussed in a comparative way, and you learn so much from reading of decisions in different jurisdictions and seeing some of the common themes and some possible divergences. So I thoroughly enjoyed the book, and it was an absolute pleasure to read it. I also, for once, agree with a lot of what Paul is saying, which puts you in a quite difficult position. So Paul and I used to co-teach a course in which we would sometimes cook up disputes just to give the students something to talk about. So in the spirit of that, Paul, I may be doing something similar just to give us something to discuss. So forgive me if I play a little bit the role of devil's advocate here. I will start by saying that I do agree with a lot of what Paul says in the book. So I do agree with him that there isn't this idea that there is one fantastic, great, monolithic theory of administrative law that we all just need to somehow discover. And once we discover it, the whole world will be put to rights. That doesn't exist. I agree with him. I also agree very much with the values that he sees as running through judicial review, and that a lot of what is going on in administrative law cases is building on and turning back to these values in very specific circumstances. I think Justice Hogan is right that the text plays a crucial and important part in a whole lot of administrative law decisions, and we forget that at our peril. But also underpinning it, particularly when developing the common law, I do think we see these values and agree that there is value in self-realization, good administration, electoral legitimacy, and decisional autonomy. So this is putting me in a tricky position to come up with something to prompt a sort of discussion and a debate without really forcing a full-on blown criticism. So my thoughts really turn to two areas. And first, I want to talk a little bit about methodology, which I think is something that we often ignore in public law, not just in terms of thinking about comparative law, but also how we're going to go about looking at cases. So I want to discuss what I think Paul's methodology is, some of the possible strengths and weaknesses of this approach, and an alternative possible approach. Then I want to talk a little bit about how far we should think not just about values, but how those values might need to be filtered through different functions that administrative law might play. And I'm going to try and illustrate these two ideas by focusing on one dispute in substantive legitimate expectations, which is looking at the different divergent views of Paul and Professor Jason Verhulst, and what this might illustrate about this aspect of methodology, and perhaps the introduction of a focus of purpose and function rather than just values when looking at administrative law case law. So first, methodology. So you can all fall asleep now for a bit as a theorist waffles on about methodology. So what Paul is doing is adopting an interpretive approach. And there's a lot of value to this approach. I think he's right that sometimes administrative lawyers can get too bogged down in one particular question. Can we justify what the courts are doing from a constitutional foundation? And I think he's right to take a step back and say, well, we have to think about what is actually going on in the case law. What are courts doing? How are they deciding these cases? And how can we understand the way in which they apply cases? So I like the interpretive approach. I think it's a valid approach. I think it adds a lot to how we think about how administrative law works. But there are some potential problems that I think we need to think about. So first, this is borrowing from, and I will say it in hushed tones, private law. Can we, as public lawyers, take an approach that is traditionally used in private law and apply it in public law? Or are those who harp on about constitutional foundations right, that in some senses, when we're thinking about administrative law, it's different from when we're thinking about just private law, because the courts in some sense are performing a different role when they're holding the government to account than when they're holding private individuals to account? And should this make a difference to how we think about administrative law? Now, I don't think it necessarily should, but I can understand how some might think that a methodology used in private law might not necessarily always be suited to public law cases. The other thing that I wonder about is Paul's approach is very much about thinking about a plurality of possible interpretations. So this isn't offered as the interpretive theory, it's offered as a plausible interpretive theory. So me being me takes a step back and thinks, well, how do I choose between these different plausible interpretive theories? Why should I choose Paul's theory over someone else's theory that is also taking an interpretive approach? And I think there are some suggestions in Paul's book that can help us make that choice. So one aspect is, how far does it fit to the case law? Is this a theory that is not related to any cases at all? Does it have complete transparency, is able to explain all the cases? Or does it explain most of, but not necessarily all of the cases? And I think most interpretive theories would probably, like Paul's, be a plausible explanation, not necessarily a perfect fit to every single case. So then the question becomes, well, how do I choose between these different plausible explanations? And what I would like to suggest is one way of thinking about this is thinking about these different theories, not just as different possible interpretations, but as different models of how we think about administrative law. And when we think about different models of what's going on in administrative law, then this allows us to take a step back and ask ourselves different questions. So we think about, what is this model trying to do? Is it trying to explain case law? Is it trying to give us a normative framework from which to evaluate case law developments? Is it there as a model that we can pass on to Justice Hogan or use to predict what Justice Hogan is going to do? We know that they're going to decide the case in this way because my model would suggest that this is how courts would decide these kinds of cases. So there are different things models could do. And once we think about what the model is trying to do, that can also help us think about whether models are competing or just talking past each other. So constitutional foundation models are doing a different job to what Paul's model is doing. So if we understand that, we can recognize that to try and compare and contrast them isn't necessarily going to help us because they're doing different jobs. The other thing we might want to think about when thinking about models is different models can promote different values. So when we're trying to evaluate different models of administrative law, we're thinking not just how well might they explain case law, but we might be asking a different question. Is this feasible? What models is what values is the model trying to promote? Is it resting on assumptions that I think work in a particular legal system? And then you can take a step back and analyze, will it achieve those values, but also debate the different values underpinning it. So I think thinking about it in terms of models might help us to evaluate these different types of interpretive approaches. That brings me to my second theme that I wanted to talk about. And that's how far, when we're thinking about different models or interpretations of the case law, should we just be looking at different values? And how far do we need to recognize that sometimes administrative law is doing different jobs in different cases? So to give you an idea of the different jobs it could be doing, sometimes administrative law is there to go away and make sure that an administrative body does what it's supposed to do on the text. So administrative body is supposed to go away and give a grant to a particular individual in certain circumstances. The individual says, I met these circumstances, you didn't give me my grant, where is my grant? So we're focused on ensuring that individuals get what they're supposed to on the system. The system is working, in a sense, protecting individual rights, but also facilitating good administration. Sometimes we see this not just in terms of protecting the rights of individuals, but upholding public goods. Is this administrative body behaving in a fair way, such that it's fair to everybody, not just the individual before the court? Sometimes the function might be to provide some kind of constitutional safeguard. In some situations, you might need a kind of backstop to make sure values aren't eroded accidentally by the administrative body. Sometimes judicial review is performing a different constitutional function. It's trying to make sure there's a proper separation of powers between different bodies. So checking on the Parliament or the executive, making sure the executive isn't taking powers from Parliament or taking powers from the court. It's checking that balance between these different institutions. And I wonder whether, in addition to thinking about values, we also need to think about what is the case doing as well as these values, to give us a deeper understanding of what's going on. And to illustrate what I'm getting at in what can be quite an abstract way, I want us to think a little bit about substantive legitimate expectations. So when Paul looks at substantive legitimate expectations, he thinks of it very much in terms of these underpinning values and looks at how we can shape the case law as substantive legitimate expectations to facilitate these values. When Professor Barujas looks at substantive legitimate expectations, he wants to do something different. He wants a nice, rigid, clear taxonomy that is obvious, that would narrow down substantive legitimate expectations to specific representations, almost akin to an estoppel. Okay. And you might say, well, how should I decide which one of those models is better? Which one of these interpretations is better? And I would suggest you need to ask yourself, what are these theorists doing? Why are they adopting this theory, and what value are they trying to promote through adopting this? And are they doing this for different purposes? Is Professor Barujas more concerned with ensuring that the courts are not acting beyond their constitutional role than Paul? If so, what does that tell us about their different theories? I also think that asking about the purpose might be useful, because sometimes a strict taxonomy might be useful. Because if your purpose here is to give a very clear account of aspects of individual rights that promote legal certainty and good administration, a nice clear taxonomy would help the administration. When am I creating a right by this expectation and when am I not? And it would also help individuals know with legal certainty when they should go to the court, when a promise is something that is actionable. But also sometimes the point of substantive legitimate expectations is to plug gaps to promote values when other doctrines might not work. So what happens if you have a policy choice that someone's relied on, but not to their detriment or not in a specific individual group? Could the values in some circumstances require protecting in those instances? And so thinking about these different purposes might help us understand which of these different interpretations we might want to use. So to conclude very quickly, it's an excellent book you should all read. And these are just suggestions of pushing Paul's theory even further to build on what I think is already an excellent foundation, because Paul knows me too well to know that I'm not going to find something to argue with him about just for the fun of it. But thank you so much for giving me that opportunity.
Thanks, Alvin, and thanks also for the impeccable timekeeping in the words there. Our final panelist for this evening is Dr. Joanna Bell, who's an associate professor at the Law Faculty of the University of Oxford, and again is an expert in administrative law, and again has published extensively on many of the topics that are covered in Paul's book, such as legitimate expectations, reason giving, review, statutory construction, and standing. So without further ado, let's introduce Dr. Bell.
Thank you very much. So firstly, I'd just like to thank Paul and the organisers of the event for the invitation to take part. It's a real privilege to speak alongside Justice Hogan and Professor Young, and especially to speak on such a beautifully written and compelling new book. So I read this book with great interest, and it's a novel and very ambitious project concerned fundamentally with the commonalities between judicial review in 5 different common law systems: Australia, Canada, England and Wales, Ireland and New Zealand. I couldn't help but think about the 1950s when I read it, because in English administrative law, that was a really interesting time when new competing administrative law books were emerging. And there's a lovely story in which John Griffiths, one of the authors of these texts, was asked to comment on what he thought of Stanley de Smet's offerings. And he said, "It's an excellent book, but it's not the book I could have written." And I think a lot of us will feel that way about Paul's book. To write with insight and expertise across 5 different jurisdictions is really quite a feat. And I certainly learned a lot from reading it. So just a few things about me. So I very much self-define as an English and Welsh judicial review nerd, which means I spend a lot of my time, perhaps more time than is healthy, reading judicial review cases. But my expertise is very much in English and Welsh administrative law, and my comments will reflect that. Now, in the time that I've got, I'd like to really talk about 2 different things. Firstly, the theme of similarities and differences across common law systems, and Paul's book really sort of sparked a couple of questions in my mind about that. And then secondly, a sort of bigger question about where we find administrative law and what we're trying to explain when we set out to explain administrative law. So beginning with the first, similarities and differences across systems of judicial review. As I mentioned in the introductory remarks, a striking feature of this book is it's concerned explicitly with commonalities across 5 different jurisdictions. And to summarise very briefly for anyone that hasn't had the chance to read it yet, Paul's central thesis is that firstly, there are lots of these commonalities, and secondly, that they can be explained, best explained by reference to 4 values: individual self-realisation, good administration, electoral legitimacy, and decisional autonomy. And what Paul is inviting us to do is to see the principles of judicial review through that lens. So in some areas, argues Paul, these values all point in the same direction. So in procedural fairness, there's not much conflict between the values, and the basic principles by and large can be seen as an expression of all of those values in one go. Whereas in others, the values pull in different directions, meaning that judges are left to try and accommodate them to the maximum extent possible, but recognising that sometimes some values must give way to others. I think reading Paul's book, it's difficult not to be struck by the degree of commonality between the 5 systems that he talks about, and he finds many commonalities to comment on. But one thing I did wonder was if you did the opposite project and you set out looking for differences and tried to explain those differences, what perspective would that give us on judicial review? And would we learn something of value from doing that? Now, one reason I raise this is that I can think of plenty of peculiarities, aspects of judicial review in my own system, which I think can only be understood by thinking about them in their context. So just to give one example, the leading standing case, or one of the leading standing cases in the UK, Fleet Street Casuals, I don't think you can understand that case without understanding the procedural reforms that immediately preceded them, the procedural complexity that plagued the law before those reforms, and also the tax legislation that sits in the background to the case. Another reason I raise this is I wonder whether a deep exploration of those differences between different common law systems of review would help to shed light on some of the puzzles that Paul usefully draws out in the book. So one thing that I thought was very refreshing and interesting about Paul's book is the transparency around how difficult some of these chapters were to write compared to others. If you're writing a book about commonalities, you know, Paul is very explicit. It's easier to write about procedural fairness than it is to write about review by reference to unreasonableness or error of law, because of the doctrinal structures in these systems being quite different. And I do wonder whether thinking about whether there are differences between the systems can help us to explain this. So just to give one example, and speaking specifically about review for errors of law, I do agree with Paul that it's easy to overstate the differences between, for example, the UK and Canada. So in the UK, unlike Canada, we don't formally recognise the idea that we can defer, courts can defer to the interpretations of law given by a decision maker. But it's very much true to say that that is a starting point only, and that courts are cautious about getting the big red marker pen out and overly defining statutory terms. They take into account the views and the position of the public authority. But while it's a starting point only, I do think it's an important one. And I think it's reflective of the role that judicial review really plays in England and Wales. So certainly in England and Wales, the vast majority of judicial review is against central government, ministerial departments and local authorities. And in both of those contexts, at least generally, in my view, there are very good reasons why it should be courts that generally determine the meaning of the statutes. And one question I don't have the expertise to answer it, but it's part of the explanation for the apparent differences between England and Wales and Canada, for example, that the bodies that are subject to judicial review most commonly are different. So that an idea of deference makes more sense in Canada as a starting point than it does here. The second theme I wanted to speak to is something that has been occupying me a lot and was really sort of came out very clearly from reading Paul's book, which is the question of where we find administrative law. So picking up on Alison's point about the interpreted methodology underlying Paul's book, very much offered as an interpretation somewhere between an explanation and a justification of administrative law. But I guess I'm raising the question of, well, what is the material? What is the data that is being explained by that interpretation? And it struck me from reading the book that Paul's answer to that would perhaps have two aspects. One, I think that Paul sees the primary materials of administrative law as being general principles of judicial review, whether they be the grounds of review, the principles in general on which remedies are awarded. And I love the remedies bit of the book, by the way, or the principles on the scope of review. And secondly, case law that speaks to those general principles. So judicial reasoning which develops the principle of legitimate expectations, etc. And because there's not much first instance case law dealing with those broad questions of what are the principles, there's a natural gravitation towards appellate level decisions in the book. Now, I want to just raise the question of whether we find administrative law in other places. And three places in particular spring to my mind. Firstly, statutes. The vast majority of public decision-making power, certainly in my own jurisdiction, is conferred by and set out in statutes. And unlike the Victorian predecessors, these statutes are often highly detailed and are often supplemented by reams of statutory instruments or other forms of delegated legislation. And one consequence of this is that statutes take up a lot of practitioners and judicial time. Both in the sense that lots of cases raise narrow questions of statutory construction and because the grounds of review interact with these statutes in lots of different ways. Second, policy and guidance, sometimes called soft law. Policy and guidance is playing a huge role in both shaping decision-making on the front lines and also in shaping how courts apply grounds of review in particular cases. And then thirdly, adjudicative forums other than the appellate courts. So obviously, appellate court decisions are really very important and they speak to the general principles that Paul is setting out to interpret here. But only a small handful of judicial review challenges are appealed. And even of those that are appealed, these decisions can still turn on very, very narrow questions that aren't really of broader interest to those general principles. But to understand what day-to-day judicial review looks like, it is important to factor them in as well. Now, I think in choosing how we define administrative law and what we include in our remit of study and teaching and what we don't raises lots of really interesting questions. One concern must surely be manageability. And if we pack too much into the definition, is there a risk that we become a jack of all trades and a master of none? However, I do have a couple of concerns about defining administrative law too narrowly and not including that list of three things that I mentioned. So the first is that as legal scholars, we might risk becoming too abstracted from legal practice and painting for ourselves a distorted picture of what judicial review looks like. So appellate decisions which set out a broad framework on legitimate expectations are highly interesting, but they're not the day-to-day work of our practitioner, which involves working through swathes of legislation, policy, and also highly specialised case law. Now, of course, I'm not saying that the priorities of legal scholarship should be based solely on what happens most in practice, but I think it is important to maintain a sense of proportion. And this leads on to a second concern, which is the importance of having a sort of more day-to-day big picture understanding of what judicial review is when questions of reform come up. And that, of course, is very topical in England and Wales at the moment, with the independent review of administrative law and the bill currently before Parliament. I think scholars can make a really important contribution in making sure that debate about reform is informed so that we can evaluate the proportionality of claims that there's a problem, and can also think about what the realistic impacts are going to be of proposed reforms. Now, by saying this, I don't in any way mean to deny that the principles of judicial review are not important, and this book is an excellent contribution on those principles. I suppose what I'm trying to do is offer a reminder that these principles are not isolated in practice, and they are part of a much bigger, complicated picture. So by way of conclusion, let me just thank again Professor Daly and the organisers for inviting me to take part. Understanding administrative law in the common law world is really impressive, an ambitious contribution to the field, and like me, I'm sure its readers will take an enormous amount out of reading it.
Thanks, Joanna. Thanks, and thanks to all the panelists for a really stimulating set of contributions on the book. Our final formal speaker this evening is the author himself. Just a reminder before I introduce Paul or give him an opportunity to speak, if you do have any questions, any of those who are watching, you can put them in the chat box. And at this time, at the end, we will come to them just before we conclude. Paul.
Well, thanks very much, Owen. And here I am above the Rideau Canal in Ottawa, on the traditional lands of the Algonquin people. And I find myself, first of all, questioning my methodological choice in going last and not getting my retaliation in first, as it were. These are it's really wonderful to have such stimulating comments and discussion and thought-provoking discussion, which is going to have me. I'm going to find myself staring at the ceiling at 3 in the morning, I think, wondering how to respond. But let me try and make 4 points very briefly, picking up on the various themes in the comments. First is, like Justice Hogan, I think that the general principles of administrative law have generally been very successful and very adaptable in really a context of extraordinary social and economic change since the 1960s and 1970s. And so there was one of my primary interests, I say it in the preface, was to mount a defense of the principles of judicial review, which are sometimes, the legitimacy of which is sometimes called into question. And we'll see transparency as a theme throughout my remarks, and I'm transparent about that. I think these principles are generally a good thing and ought to be defended. I'd also say, in response to Professor Young's mention of private law, I do say that what we're seeing in terms of development in the general principles of administrative law is a little bit analogous to the development of general principles of private law a century earlier. If you go back to before the Judicature Act in the latter part of the 19th century, you didn't have any books on the law of tort or the law of contract. You had writs and you had court decisions explaining when the writs would be granted. You didn't have any general body of principles, which you could call tort law or contract law. That comes later. Administrative law is about 100 years behind because we didn't sideline the prerogative writs, which you still see in some form, but they're not as central as they were in the 1950s when De Smith and Griffith were writing. And what we're seeing is a working out of those general principles in jurisprudence in a time of, like I say, great social and political and economic change. The second point I'd make is about methodology and methodological pluralism. And I'd say I'm a pluralist in the sense that there is a plurality of values that I rely on to create and support the framework I suggest for understanding administrative law. But I'm also a pluralist when it comes to methodology. And I don't think that I have the last word on the subject. I certainly hope I don't. Dr. Bell has written an extraordinary book, a wonderful book called The Anatomy of Administrative Law, which questions the search for any sort of general theory of the subject because of the inherent specificity and complexity of the subject. And all I would say in response, I think, to both Professor Young and Dr. Bell, is that I suppose at my core, I'm an Aristotelian, and I think that you have to, everything is teleological, and you have to ask yourself, has the person or the thing achieved the purpose which it is which it should be achieving? And my purpose here, and I'm very transparent about my purpose, is to understand the general principles of administrative law. And that doesn't mean that I don't agree with Dr. Bell that in most cases, in the High Court in England and Wales, or the Federal Court in Canada, or state courts in Australia, that the general principles of judicial review will be very much in the background. And what's in the foreground is statute and the need to listen to the sovereign voice, as Justice Hogan put it, case law in a particular area. And if you look at Canadian immigration law, for example, looking at federal court decisions, it's always very highly fact specific. It's always very much specific to particular little subsets of immigration law. You could really drill down into Canadian immigration law and talk not just about immigration law, but permanent residency law or refugee law. And even in refugee law, you could talk about internal flight alternatives, state protection law. You could talk about all these things. Again, so what I say is we have to be clear about our purposes as scholars, and what are we trying to do when we sit down and write a book. And like I say, for me, what matters here is the core of the general principles of administrative law, which I see as being common to the 5 jurisdictions in question. And it's true that I can't explain difference, and it's true that from a comparative law perspective, I've set out to identify commonalities, and you could equally set out to demonstrate difference and arrive in a very different place. But given my purpose, given the teleology that I have taken upon myself, that's where I end up, is with the general principles of administrative law, to try really and create a framework which helps people speak across jurisdictions, but ultimately just to better understand what can be a very complex subject, which has grown like topsy over the last 40 or 50 years. The third point I'd make is about the challenges that you face in writing a book like this one. The complexity of administration, as Dr. Bell explains, is one challenge. How do you design a framework which is adaptable to complexity? How do you adapt across jurisdictions? How do you account for tensions between different features in the case law? I call them values. But how do you account for, in legitimate expectation, the desire to give effect to the sovereign voice of the legislature on the one hand, and the desire to do justice in individual cases on the other? Institutional differences are also a significant challenge. Professor Kane, in his excellent study of administrative law in the United States, Australia, and England and Wales, explains that much can be attributed to institutional differences. And I think, like Dr. Bell, that institutional differences might indeed explain to some extent what has gone on in England and Ireland as opposed to Canada in terms of deference on questions of law. But again, we're back to the question, as Professor Young put it, of purpose. And I would say, what's the scholar's purpose? And the purpose isn't to explain those institutional differences. It's not to offer an institutional theory of judicial review. It is to take the core features of judicial review, which are common across these jurisdictions, and construct a framework which enhances understanding. And Professor Young talked about fit and justification. And in chapter 9, you'll see I have a list of criteria that I offer up to measure my framework against. And the last thing I would say is that the framework is responsive to those challenges. In fact, one of the difficulties I had with the peer reviewers was that they suggested didn't explain enough, that the framework was too vague, was too abstract, and not because it was responding to these challenges, it was too general. But again, I would say without saying everything, I'd like to think I've said something about the topic that I chose to address, except it can't dictate every outcome. And I would like to think, as Justice Hogan put it, that it does have some moral value, that it does indicate that in generating and applying and upholding general principles of administrative law, the courts are doing good work, and work which should be celebrated because it furthers individual self-realization and the dignity and autonomy of individuals, respects electoral legitimacy and the mandates of those who have stood for office. It makes sure that there is a distribution of functions in the administrative state, and all this without compromising the ability of the state to engage in good administration and to achieve its objectives. So thank you for thought-provoking comments. I'm sorry I can't offer anything more by way of response, but I will let you know how those 3 o'clock ruminations go.
Thank you, Paul. Just to conclude then, as we're approaching the end of the time, I'd again like to thank all our panelists for their comments. I'd like to thank Paul for the invitation, well, for writing the book and to begin with, giving us an excuse to have the event and also the invitation to have it today. I'd like to thank everyone who has attended virtually. And I'd just like to echo and kind of agree with Paul's last comments. You know, someone who does a bit of academic work and a bit of practical work, I think the book has significant value for both fields, and there's a huge amount for academics to engage with. But the framework provided is something that also, I think, is of significant value to practicing lawyers. I think Dr. Bell is correct that on a day-to-day basis, practicing lawyers may not worry about theories and general principles and worry more about the details of the individual case they're dealing with. But those general theories and general principles, I think, provide a framework and are very programmatic in the way they shape courts' decisions, the way they shape arguments, and they provide coherent roadmaps for practical arguments. So I think there's a lot for everyone in this. And I think I'll probably conclude by saying you should buy the book, you should read the book, you should use the book, and engage with the book. So thank you all for your attention today.
Thank you.
Thank you.